predates our appearance. And it is at that appearance, notwithstanding the facts as asserted in that affidavit, an undertaking was made. So if those facts were not relevant prior to the 7th, and the very facts, notwithstanding the very facts, they were able to make specific undertakings, which included filing by the 8th of July and appearing on the 15th, I truly do not understand how then they become relevant come the 15th. They revive, they suddenly become relevant. The challenge with this application is nothing in the affidavit speaks to the period between the 7th and the 15th. Nothing happened that even threatened the undertaking made to you on the 7th, Chair. So the question is, why must I entertain this entire argument, if not to waste the Commission's time? Mr. Matlala's legal representatives were informed by certain facts to conclude that they're in a position to make certain undertakings on his behalf. They don't come here and say, those facts have changed. They don't come here and say, since the undertaking was made, new facts have come to light that make it impossible for us to comply. So technically, that undertaking made is not worth the paper it's written on. And this is a complete waste of the Commission's time.
Can you,
now,
sorry,
yes.
Mr. Lo. Can you please make me understand something Ms. Van der Heever said on the 7th?
Yes, Chair.
That she was agreeing to the filing,
yes,
by the deadline that was indicated, something like subject to the reservation of Mr. Matlala's rights. Even as she said that, I wasn't sure in my mind what exactly that meant. What was your understanding?
My understanding...
Of course, maybe I should have asked, I should have put that question to Ms. Van der Heever.
It's a subject, of course, to Ms. Van der Heever confirming,
yeah.
But I had understood that the proviso was filed on the 8th, subject to Mr. Matlala's right to supplement statement filed. That was the reservation made.
Because there could not be an undertaking to file, but at the same time not to file. An undertaking
yes.
not to file.
And in fact,
it's even wrong for me to refer to the latter as an undertaking. Yeah.
And in fact, that proviso was discussed amongst ourselves because of the tight timeline they then had to file by, having missed previous deadlines. The only way to cure any potential prejudice to Mr. Matlala was to agree and place on record that he reserves the right to supplement. We thought it is a natural way to go, and he's entitled to supplement whether or not he has reserved that right in any event. But to the extent that it was necessary to articulate it in no uncertain terms, we were agreed to that. So that was the proviso, Chair, that was not charged.
All right.
Please, the filing.
Please continue.
Thank you. So at the end of the day, what the legal position is regarding Mr. Matlala's constitutional rights, as posited by my learned friend, is irrelevant for our purposes. She may very well be correct, she may very well be wrong, but it doesn't advance the issue any further. Those rights existed on the 7th when she made the undertaking, unless she suggests that they have since or very recently been earned. I listen carefully and I resist the urge to argue that this is a moving target. And each time we think we've got the target, then that target is going to move. And we are continuously chasing a rabbit we cannot catch. And Chair, I implore you and commissioners to please put an end to this. Witnesses come here and make undertakings. They give dates. We work on a very tight time schedule. Either witnesses respect the rulings given by the Commission and adhere to those rulings and file, or either appear on the dates that have been either directed by the commissioners or on which they have made undertakings, because otherwise it makes the work of the Commission impossible. We now have to change things about. We now have to find another slot for Mr. Matlala. We now have to plan for him when to give an affidavit, a statement, and to find a slot. And all this time, it's in circumstances where this commission has got a limited time span left to it. I'm concerned about the approach being adopted by Mr. Matlala's representatives, and I don't think it is particularly appreciative of the challenges that the commission faces. As to whether or not the commissioners and the chair will permit the rulings handed down to be wantonly disregarded, as for the commissioners to decide. But I wouldn't be surprised if the commission holds a dim view of that. So, the difficulty we have, or I have personally, listening, is, and I do accept that I possibly misunderstand Ms. van der Heever. The plea agreement with IDEC, the aborted or stillborn plea agreement with IDEC, at the risk of stating the obvious, that has got absolutely nothing to do with this commission. What this commission is interested in is its terms of reference. It's interested in the issues that were raised in the Rule 3 notice that was served on Mr. Matlala, as well as the subsequent Regulation 10.6 notice. That's all where this commission is interested in. I'll rephrase that. That is all the evidence leaders have indicated they are interested in. The commissioners may expand those issues. What position Mr. Matlala assumes in response thereto is his choice. We desperately do not want to be a part of a discussion on how does he respond to a particular question. If a question posed invites a defense, a Section 35 of the Constitution defense, so he must state, and then we will deal with the defenses raised, when he appears.
And as I put it to Ms. van der Heever, it cannot be that everything he could ever say is covered by or by Section 35.
Indeed.
Or bears relevance to the Section 35 protection. It can never be, and Ms. van der Heever accepted that.
Yes, Chair.
And facts are facts, and they should not change in accordance with whatever it was that went on under the plea deal. But as Commissioner Baloyi said, that's null and void anyway.
In any event. And once again, it depends on whether I understood her correctly. It gets worse, because now it sounds like the commission shall be hamstrung by any plea deal that Mr. Matlala may choose in any criminal trial, whether ongoing or in the future, to conclude. So, effectively, if Mr. Matlala were to tomorrow face 5 charges in five different criminal trials, and he considers whether or not to conclude a plea deal in any one of them, then this commission is hamstrung, unless I completely misunderstood Ms. van der Heever. My understanding would be, I don't believe she would suggest that. But at the same time, then I struggle, what exactly is being suggested regarding these plea deals? And once again, I have no clarity. I submit, commissioners, that the only position to assume is we have nothing to do with any plea deals that Mr. Matlala chooses to conclude anywhere in any court. He has 2 defenses in this commission. It's a Section 35 defense, or buttressed, in fact, by Section 8, sub 2 of the Commissions Act, that anything he says that would incriminate him cannot be used against him in any criminal case. So he's got 2. He can raise them. So why we are having a debate about plea deals and whether or not his legal team understands the facts that underpin such a plea deal is a challenge to me. Now, the offer, mindful of the time, made to file in 2 weeks, I can accept. In any event, it's up to the commissioners. However, the offer, if I understand it correctly, sounds to be conditional, and this is what the condition is. It's dependent on whether or not they get the requested information from either IDEC to enable them to answer the questions posed. If I misunderstood, because I think Commissioner Baloyi indicates there's shaking her head as if I misunderstood her.
I think the ultimate position was they will file a statement.
If it is wholly unconditional by a specified date, then I'm happy. Because my concern was that if they do not get the required information from IDEC, or IDEC just outright refuses, then they would be entitled in law to approach a court to compel IDEC to provide such information if they have a basis in law to do so. And if that court case is unfavorable to them, there are appeal proceedings. So the question would be, do we await that information and the challenge to right to that information to run its course until the Constitutional Court before we get a statement? But I will accept what Commissioner Baloyi says the filing in 2 weeks is unconditional. If that is the case, then we just need to set a date. And if the statement is not filed, we shall be back before you, Chair. And I suggest that the consequences will follow. What then must happen now is to lock in a date, as we did of the 15th that has now collapsed, as to when Mr. Matala will appear. And I say so because we as the evidence leaders have to go rejig our program and accommodate the new dates, while at the same time making sure that there is sufficient time for everybody to prepare for Mr. Matala's appearance before you.
Would the preference be for the postponement to be to a specific date or a date to be determined?
No, Chair, I would prefer a specific date at this point.
Specific, all
Yes.
right. All right, please continue then.
Thank you, Chair. And to assist perhaps the commissioners to consider a possible date, my learned friend will confirm, I understood that the upcoming trial that starts on the 20th.
Just a minute.
Yes, Chair.
I think on your last point about the date, I think it would be better for you and Ms. Den Heever to engage, and then, which of course would necessitate a stand down. And when we come back, hopefully we'll get an agreed date.
Oh, no, I'm happy with that approach,
Yes.
as long as I come out of this hearing with a ruling on a date, Chair. However that point is reached is irrelevant.
Yes,
I'll accept
yes.
that, Chair.
Any further submissions?
No, Chair, I think that will suffice. I'm looking at the time. As the commissioners are aware, there's another administrative issue to deal with before my witness returns to complete his testimony.
Any reply, Ms. Den Heever?
I'm going to be very brief, Chairperson.
Yes.
I'm not going to go back to the issues of the plea deal. I've got experience in that regard, and I know it's important. And at some point in time, I will demonstrate to you what the importance of that is.
Yes.
The second thing, my learned friend says that subsequent to the date of the 7th, nothing happened. The affidavit sets out quite clearly what happened subsequent to the 7th. The 13th, we were back in court. There's also the issue on the 8th, the recordings were disclosed and what happened there. So my learned friend is not correct when she says there's nothing. It's been set out chapter and verse what transpired from that date on. And the thing that's quite important, Chairperson, is I don't believe this commission, and I've said it before, as you recall, we're not here to ambush witnesses. And it's for that reason that I'm entitled to ask, if you're in possession of certain material that you wish to use against my client, I'm entitled to ask for it. Because that way we level the playing field. So it's also that also needs to be taken into account. Lastly, you were quite right. I did reserve my right twice.
Or just before you move to a different point, wasn't everything that Mr. Matala required given before the 7th of July?
We said that there must be certain recordings. We then given 13 voice files. We then said it's clear somebody went and extracted, like cherry picked and given us 7 voice files. We now want the complete recordings from which these were extracted. We were then given on the 8, I think, recordings, 2 recordings. There's in fact a 3rd recording that was not given to us. Then we were handed over, I discussed it with my learned friend, and she made some inquiries. We were given a transcript, an unofficial transcript of the one. So, and these are long. The one is 6 hours and the others together is longer than that. So, and the client must sit and listen to it because he needs to ensure himself. So that process wasn't even concluded. And then lastly, as I said, it's just an issue of, I did reserve my right because I foresaw what was going to happen at that point in time. It was not a condition I will file and then amplify. I just couldn't because at that point I still hadn't had any access to the client to discuss any of the issues relating to, as I said, let's call it the Medicare 24 matter. One more thing, Chairperson, I'm going to ask you and the Commissioners to consider the following. I'm going to ask that we be assisted and that an order is made that we get access to the client over weekends with electronic devices, in other words, with the computers, to assist us in dealing with all of these things. It's very difficult if we can't do that. It's the times that you can see the client is limited. There's only a limited number of legal practitioners at any given time that can see the person. And if you were to see him in the normal way, there's a thick glass and you can't listen to recordings. So we would like, if there's any way that you see open, that we be allowed for this weekend and the next weekend to get access. After that, we won't need it because the last weekend would be just before the filing. Because we're also starting on Monday, he gets transported, very limited time in court because we're running the trial. So what we can do is we've had consultations long before. It's actually a much simpler matter than anybody has made it out to be. And that's why for that it was easy. We've given the client the dockets that was disclosed, and when we had opportunities, we've discussed with them our defence, our plea. So that was, and we had 2 person-to-person meetings that was allowed by the